SJC-12674, TDVJO.
Mr. Traft, good morning.
Mr. Chief Justice and Associate Justices, I please the court, Michael Traft on behalf of the mother, J.O. During the marriage in this case, the father committed a series of acts. At one point, he pressed the mother against a refrigerator and punched the refrigerator right beside her head. On another point, he pulled her hair because she had tried to walk away from him, slapped her, and smashed a special vase that she had cherished. At another point, he had pushed the mother down the stairs because she was talking to her own mother on the phone for too long, according to him. These last two incidents were all in the presence of the child.
You know, how many of those instances that you've described are in the record in front of us?
All of them.
All of them, okay.
Because they were referred to in the, and admitted to in the testimony of the father in the record, in the restraining order transcript, which the mother tried to have admitted, which the trial judge refused to have admitted.
Counselor, going back to Justice Cipher's question, I guess there are two questions. It may be in our record. Which of those were within the record that the judge admitted in terms of making her decision?
None, because she refused to consider any of that.
And all of those, I gather, occurred before the divorce judgment?
Correct. And for that reason, the judge made a determination that she couldn't consider any of the substantive evidence that occurred prior to the divorce judgment. And so she didn't consider any of those. And she didn't consider what the trial judge, divorce trial judge, ultimately determined was a particularly egregious incident, which is an incident in which she ran into a spare bedroom in their home and locked the door. He smashed the door down and came up against her and held her against the wall.
Were any of these facts presented to the GAL who investigated this? There's a GAL that produces an investigation for the modification judgment, right?
Right.
And is all of this before that GAL?
Well, not specifically, because these were discussed to some extent before the GAL in the original divorce. And the GAL in the modification action was again under the instruction of the judge essentially to focus on what happened after the divorce and not some of these incidents that happened before. Now, there's one other further incident that happened also before the divorce judgment, which the judge refused to consider, which was considered to some extent by the second GAL. And that is an incident that got the mother into trouble relating to the modification because she reported it to, hadn't reported it at all to before the divorce trial. But because of her concern of what had been going on since the divorce trial, she reported to the police an incident that happened in 2013 of an angry argument in the Danvers Mall, where the father had grabbed the keys from her. They both had arrived at the mall in separate cars. The father had grabbed her keys as she was putting the child into the car. She was trying to drive away and stop the angry argument that they were engaged in. And he grabbed the keys from her. According to her, he fired them at her head. And that led to, after she reported this to the police, to a probable cause hearing.
What role does the other findings about the 209A order and the criminal complaints that they were dismissed and not found credible by other judges play in this?
Well, you have to realize what wasn't found credible here. The 209A order, the issue is not whether any of these incidents occurred in the past. The issue is there a risk and a danger at this time to justify continuation of a 209A order? The original judge, after hearing this, ordered it, and then, of course, there's the full hearing of a 2-day hearing. And based upon that testimony, this was a good defense to a 209A order. The defense by the father was, this all happened in the past, I'm a good boy now, I won't do it again. And therefore, she's not in danger. That's a good defense there. With respect to the criminal charge, a good defense to the criminal charge was the idea that I didn't really throw those car keys at her head. What I did was I gently dropped them in the back seat of the car.
This was a clerk's hearing, right?
Correct.
And then a complaint did not issue.
And the complaint did not issue.
And this was all before the modification judge.
It was before the modification judge in this sense. It was part of the father's claim that the mother's rights should be limited because she was going to courts and trying to get him in trouble like this. But it wasn't considered by the judge in terms of whether this was an act of domestic violence that ought to justify a consideration in terms of whether she was going to change the custody order. She made a clear line distinction by saying whether any of these things happened doesn't matter. In fact, she once said to trial counsel, your client made a choice, and I can't consider anything that has happened before the divorce judgment.
I'm confused of what you're asking us to do a little bit, because we have a judgment in the divorce. None of these incidents that you're talking about are during the modification phase, right? All of these domestic violence incidents that you're referring to, they're not in the time period covered by the modification. You want us to go backwards to look at things in a case where we actually had an agreed upon judgment. So I'm confused with what is the rule you're asking us to do? For domestic violence that occurred before the modification period that was considered, or at least eligible for consideration, should be reconsidered? What's the rule you're asking us to do?
Well, the rule is that, and there are two arguments to that. One relates to the statute, but let me just ask just for the moment, talk about the rule that I think is necessary in other circumstances. If these issues have not been considered, and they were not considered in this case.
Well, domestic violence was considered, whether every incident of domestic violence was considered at the divorce. And also, this is a consent judgment, right? You know,
Well, and that's the point.
but there's a trial. I just don't, it just seems like we're gonna redo the whole domestic, and also, this is a case where there's domestic violence on the part of your client too, right?
No.
I thought
That
that-
is, no,
well,
there's no finding. There's no evidence, and there's no evidence. That's the whole, that's
So
the
if
key
the
point.
original judgment doesn't find there's any action?
Absolutely not, because there was absolutely no evidence. There's an affidavit by the attorney in the modification action who read over, neither of the modification judges.
I thought it was in the
attorneys.
divorce judgment. Didn't the divorce judge say something about that?
The divorce judgment has a one sentence.
I know, but
But is that a finding of a fact based on no evidence? There is no evidence in the divorce. There was nothing in the divorce trial, no discussion whatsoever. in
Did
the
you
divorce
seek to
trial.
correct that error? I mean, it's a pretty fundamental error, right, that your client is also engaged in domestic violence and you don't seek to change that? But
Well, the problem is this. The mother ultimately, as the divorce trial was going forward, decided to agree to joint legal custody. And the dispute became an issue about physical custody of the divorce. And she agreed to that because of the father's representation that these incidents had happened in the past. I've realized the error of my ways, and now that we're separated, I'm not going to engage in these kinds of acts of physical violence. And she accepted that concept to move forward.
But that's important because, that's really important because the statute you're relying on and the rebuttable presumption that you're relying on applies not just when there's sole custody, but when there's shared legal custody. And that determination by agreement was made.
Yes, that determination by agreement was made. And the fundamental issue is, after that determination is made, when the former abuser now is trying to change custody, and now is trying to give himself sole custody, can the court consider
But
all
yeah,
of this?
that's implicit in my question. My point is, that has to be considered when there's shared legal custody, not just when there's sole legal custody. And there was an agreement to shared legal custody. So the statute applied to the initial agreement.
But the statute it doesn't stop there. The statute specifically talks about consideration of past abuse. It doesn't make a temporal distinction. When you look at the DVB LEAP, I think, amicus brief, they do a survey, a national survey of how you can statutorily limit the kinds of domestic violence that you could consider when you're going back to reconsider child custody. You always have to go back and look at what is in the best interest of the child whenever you're going to try to change legal custody. And that necessarily, in order to protect the child, must look at what might have happened in the past that has been at least accepted as not going to be a problem.
Mr. Chair, suppose we agree with you, there's no temporal bar.
Right.
That because we're talking about the best interest of the child, and perhaps if there's past domestic violence, as the amicus briefs, and you argue, this is always going to be part of the relationship, in the familial relationship, correct? That's your argument?
Correct.
Under the statute, is it your client that has the preponderance of the evidence standard to raise this issue? Raise a rebuttable presumption?
To at least raise the issue that there were incidents of domestic violence, I think, yes.
Okay.
But I'm not required to.
So,
but-
and if all this evidence is before the judge, could it be said that by implicitly she discredited it?
No, because she she said, I can't consider any of those acts of domestic violence that occurred prior to the divorce, so I won't consider them at all. And as the father tries to argue, they have to be wiped out. It doesn't matter what I testified to under oath after the divorce about the domestic violence, unprovoked domestic violence that I committed. You can't consider it. You must find, as a matter of fact, that it didn't happen.
So based on the judge's preclusion of it, you say whether there was sufficient evidence or not, the fact that she did not consider it was error.
Correct.
Yeah, but your brother didn't argue that. Your brother, as I read it, he'll tell us in a moment what I heard him. I think it's fair to say it's not clear from the first judge's decision whether she found that the father had engaged in misconduct, although I think she says that they both engaged in physical assault on the other, which culminated in an assault by the father against the mother in 2011. So she at least found that there was something quite serious that happened in 2011. I don't think she makes any explicit finding as to whether or not the rebuttable presumption is overcome. He says implicitly she did, but so I don't think the judge is saying nothing happened beforehand, but what she is saying is that we're not going to do Groundhog Day and revisit everything that happened in the past when we're focusing on a modification. So why is that? Is it wrong because it is the father seeking sole custody? Would it be different if the mother had sought a modification as opposed to the father?
I don't think it would be different to consider the past history. I think the statute requires you to do that, and I think it's an important consideration because whenever you're dealing with child custody, you're dealing with the interaction of the parties. And part of the problem here is what had happened and led to the modification action was the back and forth interaction between the parties that became problematic. And it also was critical to consider this when you consider the allegations as to why the father was seeking to change the custody. He was criticizing the mother's actions when she noticed a bruise on the child that looked suspiciously like the kind of bruise that had been inflicted on her when she had been abused by the father during the marriage, a particular mark. And she got three different explanations from the father and from the child as to how this happened during a walk in the woods. So she had some concerns about that and reported it. So that became an attempt to try to alienate the father and a reason to change the custody order. So she had a right to explain the whole history. The whole history, the judge refused at every stage. there's pretrial motions, and there was evidence at trial, there's attempted trial to try to bring this in any way possible, and the judge says, before I met the divorce, I'm not considering it.
Mr. Traft, I'm a little confused here. I mean, as to other evidence, would, like, let's not talk about domestic violence, let's talk about something else. I don't know, conduct at medical appointments, for example. Would the judge always, at a modification, be able to take into account non-domestic violence evidence? Or is it only by virtue of the statute that you're saying that she can always take it into consideration?
If it's relevant and material, and that's the other factor you have to consider.
I guess what I'm saying is that in a modification, is there any limit on the evidence that the judge can hear, absent statute?
No, I don't believe there is, and if it's relevant and material, and the judge can decide, wait a minute, you know, you're talking about something 5 years ago, and it's minimal as far as I can see, you're not talking about anything different from what happened before, the judge can discount that, certainly. But at least the mother has to have the opportunity to be able to present it and explain why it is relevant.
So is it by virtue of statute that domestic violence stuff can always be considered?
The statute requires that domestic violence, yes, I believe that's.
So it's only by virtue of the statute that this is different, this evidence will be treated differently?
I'm arguing both, in that I think the statute requires it. If you're not convinced that it should happen anyway, I think the statute requires it, and I think you have to follow it. And when you look at what other states have done to limit it, Massachusetts has made a clear decision not to limit it. For just this reason, for all of these reasons that you've seen from amicus briefs, is why this is such a problem and why it should be considered.
So if I can go back to Justice Kafker's question before, which I'm not sure, at least to my satisfaction, you've answered. The life of probate and family court judges is short and brutish because they have all these modification matters, that there's never closure. So are you saying that when, again, I know the father brought it here, and I'll discuss that with your brother in a moment, but if the mother here had sought modification, is it your view that the second judge now has to make fact findings that may be different from what the first judge found with regard to what happened before the judgment issued?
The second judge has to consider it, but not go over it if there's nothing new to demonstrate there's a reason why it should make any difference. In this case, you have what wasn't before the trial judge in the divorce, but what existed subsequently is the father's admissions to everything that I talked about were admissions of what the father said. There were other things that he didn't admit to that the mother alleged.
So if there's anything new, you have to revisit everything old?
If it's relevant material, you have to be able to give the.
I'm confused by that. Just
Right.
in this particular case, the judge finds the stuff that's new, the judge finds in favor of the father because he finds the mother has overreacted and then the judge has the old stuff, and I understand your point about context, that maybe she's overly sensitive because of what's happened in the past. That I get. But do you really want these incredibly busy probate judges to have to redo these divorce judgments essentially anew, as long as there's anything new? It just sounds like that's an invitation to chaos.
Well, no, because you can limit it.
But you say you earlier said as long as it's material and relevant. I don't know what that means, but it just seems like you're basically saying if there's anything new, everything old can be reconsidered. To me, that's the rule you've just developed. Is that right?
Well, to say everything may be a little bit too broad, but anything that may relate, I think in terms of the mother really has to be able to, if you're going to charge the mother with overreacting, you have to give her a chance to explain what she's reacting to and why. But if you say, I can't consider anything that was the basis for your overreaction, how can you find fairly that she overreacted?
Mr. Chair, can I ask you about the proof here? You said to us the mother detailed during the ex parte 209A hearing many instances of abuse, correct?
Yes.
And that was in front of the judge, right?
Well, it was presented in a motion to admit the restraining order hearing.
The statute says the issuance of an order, you know what the statute says, the second paragraph, precludes a judge from considering evidence presented during ex parte 209A hearing.
Well, not the,
But
no,
for purposes of domestic violence.
right, for the ex parte hearing. I'm not talking about the ex parte hearing. I'm talking about the two-day hearing, two-day evidentiary hearing with testimony from both parties, not the ex parte allegations. So it's a two-day evidentiary
The
hearing.
issuance of an order or orders on the 209A shall not in and of itself constitute a pattern or serious incident of abuse.
Correct. Because that's the issue, the initial order. And necessarily, the issuance of, the final order isn't necessarily a determination of
The
abuse.
first clause is issuance of an order. The second clause is issuance of ex parte. They distinguish between the two, right?
Right. The issuance of an order is what we were
Is-
relying on here in terms of what evidence was presented. I don't think you can ignore testimony that's admissions by the father. And the one thing I would like to say, I know I'm beyond, everybody's beyond my time so far today, but I did want to say a little bit about what should be the proper result if I'm successful in my argument here.
You a minute. Go ahead.
And I think it's a difficult issue that I've struggled with a bit, because the usual idea would be, well, we return back to joint legal custody and send it back to the trial judge and have that trial judge sort it out. The problem here is the way this case has been litigated. During the modification, the mother filed a motion to amend her counterclaim. Her original
Why
counterclaim
don't
was
you
just
tell
to
us how
bring
the
us-
case should be resolved, because I know your time is up. So how should the case be resolved? What
So,
should we do?
so the case should be resolved by providing the mother with sole legal custody, maintain the physical custody the way it has been. That has worked out okay. But by doing that, just switching the legal custody, it gives the mother the ability to make sure that things can go smoothly, and prevents the father from perhaps overreacting on his part.
I'm
if
sorry,
he's-
would you say what the result is that you want?
Yes, that the court would order that the mother be provided with sole legal custody, and that the joint physical custody remain in place.
Joint physical custody remain in place.
Right, that's right.
I see.
And that the matter been then reconsidered in the trial court, by the trial court judge.
Okay, thank you.
Thank you.
Mr. Curtis.
May it please the court, Robert Curtis for the appellee father, TD. I'd like to begin just by quoting, it's at page 62 of the addendum in my brief. This is the original divorce judgment, where the court absolutely found that the parties have both engaged in physical assaults upon the other during the early part of the marriage. So that finding was made. Not particularly detailed finding. We don't know what subsidiary facts led to that finding, but that judgment wasn't appealed, and that judgment's final. We don't have anywhere in the record here the transcripts from the divorce trial, so we don't know if all of those litany of incidents that were listed at the beginning of my brother's argument were ever heard or not. The fact is, at this point, because that judgment's final, all of those incidents preceding the divorce judgment are part of that divorce judgment now. So the question here really is, when the parties come back to court on a modification complaint and the domestic abuse allegations come back up, should the court be retrying everything that potentially was or could have been tried during the divorce
Not
trial?
everything, not everything. So let's just slow down for a minute if we could. So as my colleagues have alluded to, probate and family court judges are not going to be able to survive if every time there's a modification, everything is on the table again. It's just, it's impossible. But this is different. There's a statute. And the statute says, in issuing any temporary or permanent custody order, the probate and family court shall consider this type of evidence of domestic violence. That's what the statute says. And for children to be witnesses to domestic violence, as we all know, it can have a generational impact. So we've got a statute that says, no, you don't open the door to everything, but if domestic violence was part of the marriage, the judge has to consider it if they're going to change the custody order. That's what the statute seems to say.
Well, right, so 31A does require the court to consider the domestic violence and everything that goes with it. The first judge presumably did that because we have a finding from that judge saying that both parties engaged in physical assaults upon each other. So the first judge did that, and in spite of the domestic violence evidence that was before that judge, which we don't know what that is here as we sit here today because we don't have those exhibits or transcripts or anything, but whatever that evidence was, the judge determined it was still nevertheless in the child's best interest to have a shared physical custody arrangement. And in fact, the parties themselves agreed it was in the children's best interest to have joint legal custody because they agreed to that part of it. The judge only determined the physical custody. So everything that's in the statute with respect to those older abuse allegations was considered by a judge. So
That's not what the statute says. This is a request to change the custody situation.
Right, but
And so now the judge is going to consider a change in the custody situation. Therefore, in issuing any temporary or permanent custody order, the probate and family court shall consider evidence of past or present abuse. It's not an invitation, it's an order.
no, right. But so the question is, what evidence gets considered? What past or present domestic violence evidence gets considered? So I hate to use hypotheticals, but I'm going to have to here. Let's say the modification action is 10 years down the road, okay? And an allegation that happened after the divorce, but 9 years before the modification is certainly a past allegation. Yes, the court has to consider that on the modification, okay? The issue here, though, is whether the modification judge is charged with retrying the allegations that were already addressed by a prior judge. Right now, the second judge absolutely could rely and did rely on the fact that the first judge found there was domestic violence. That's the baseline for this case. My brother suggested that I'm saying that they go away. They don't go away. The record in this case shows there was mutual domestic violence. That includes domestic violence perpetrated by my client according to that divorce judgment. So the second judge absolutely had a right to consider that information, and she did consider it. It's in her findings. She took judicial notice of the first judgment and the first judgment's findings, and she considered those things, okay? But there was nothing new, domestic violence-wise, in this record before the modification judge that would have tied back to those previous allegations.
I think to the extent I understand Mr. Traff's argument, the part that I did grasp was, he said, look, you have to understand the context. When she reacts to the bruise, she's reacting as someone who's dealt with bruises in a domestic violence context. So the judge has to take that context into account when evaluating the new information. That to me was the best argument he had. Why isn't that part of his argument correct?
I'm not saying it's incorrect, but that doesn't mean retrying the prior domestic violence allegations. The judge absolutely could have had that context based on the 2 GAL reports that are in evidence.
So you need to then take into account the context of domestic violence, past domestic. So you agree that, I'm trying to figure out what the rule again for us is. So you do have to take into account the context of past domestic violence when you're considering a modification. You would agree with that as a rule or no?
Right, but there's a lot of...
But adding your qualification, but without retrying the case.
Correct. And I agree, but there's a lot of moving parts here. So in this modification action, you had essentially cross claims for modification, okay? So father was seeking a modification claim based on mother's actions and behavior. Now she's raising a defense saying, look, I did these things because of the context of the history of domestic violence. That's different than her saying, even though father got custody the first time around, now I want to bring up all of these older domestic violence allegations again and now take it away from him.
Well, counsel, aren't we really looking, this case really brings a broader issue to the forefront rather than just this particular case, and that is, what do you do in a situation where, for whatever reason, one spouse is unable to proceed forward with all of the information at the time because of domestic violence, but then later is able to bring it out more forwardly? Should the court be looking at that or not? Or should we recognize what happens to a victim of domestic violence And I'm not saying whether this is or isn't the case in this case, but just in broad general terms, this is a bigger issue, isn't it?
It absolutely is. And I think you hit the nail on the head when you said you're not sure if this is the case or not, because I don't think it is. I don't see where in the record it's explained why she didn't bring up certain allegations before, or in fact, why she didn't appeal the first judgment. If she felt that that line about the mutual abuse was incorrect, why wasn't that appealed? None of that's really in this record here. I mean, maybe there's one or two places where it's touched upon, but it's not in this record. But to get to your question, I do think there are going to be times where, and I'm not even sure what the circumstances may be, but let's assume that there's going to be some sort of circumstance where a abused parent didn't raise certain allegations at the time of the divorce because of, I don't know, some sort of trauma, whatever, okay? And subsequent to that, modification action sought and these allegations hadn't been brought up before. I think under those circumstances, maybe there needs to be a rule that takes that into account. And it may need to be something along the lines of you have to make a showing of, an offer of proof of what would have been offered sooner and why it wasn't offered. And if it reaches a certain threshold that, yes, that evidence would have been relevant and the excuse for not raising it is appropriate, then yeah, maybe the rule has that. This isn't that case, though. There's nothing in the record to suggest that here in this case.
But we don't know what prior issues, evidence that there was of domestic violence, because you just said that we don't know. We don't have a transcript. We don't know.
Right, but the burden was on mother to provide the court with that, and
But
she
she
didn't.
was trying. What was it that she had the burden of showing that this was what?
Mother had the burden. Well, she had. I mean, first of all, the obligation was on her to appeal the first judgment if it wasn't correct. She didn't do that. Once she got here, if there was, allegations that she feels weren't considered at the divorce trial, putting those things on the record here to the judge and explaining why I didn't,
Well, why does she have to do that? Given what the language of the statute is, why does she have to do that?
Why does she have to do that? Because
Doesn't the statute suggest that all prior instances of domestic abuse are relevant?
all prior, they're relevant in the sense of context, but not relevant in the sense of you can't modify. We have a good divorce judgment here where both parents have custody. You can't modify that based on the past allegations that the first judge had the opportunity to, assume that a party comes in after a divorce with absolutely no new allegations, but there's a new judge sitting in the session now. I want to take my shot with this judge. I'm going to come in, raise all of the same things all over again. And this time I'm going to get the presumption in my favor and I'm going to get custody. You can't do that. There has to be something. Now, once there is something, if there was evidence that in 2016 father battered mother again, which there isn't, may be clear, there is nothing in the record that says that. But if there was, then the modification judge could say, okay, we've got this new allegation that I find credible. There's your change of circumstances. I'm going to tie that to this history. And now I'm going to base my order based on the fact that this history of abuse has now continued beyond the divorce judgment into 2016.
Can I ask you, the factual predicate that presents to the modification judge comes from the affidavit, the ex parte affidavit, correct?
Could you ask the question again?
The factual predicate that, what Mr. Traff started out this hearing with, that comes from the ex parte affidavit, correct?
I think that's his argument, yeah.
And so the allegations that are before the modification judge that she has before, she has the documents, are the 209A proceedings, which didn't issue, and then the complaint that was sought in the district court, correct?
Right, although honestly, I'm a little confused. I mean, it's a big record, and I easily could have missed something. But aside from knowing that they wanted that information to come in, I'm not too sure where I see that in there. But really what we have, the actual predicate here is
the modification judge does make note that ex parte hearing transcript documents several instances when mother testified father was abusing her.
Okay.
Right.
So yeah, I was assuming that, okay.
And then we get into the district court clerk's hearing where the complaint did not issue.
Right.
So that was before the modification judge, that information.
Right, yeah. Well, that's another point I'd like to make too. So, I mean, in this particular case too, I mean, really, I get that we're looking to maybe, establish a policy going forward here, but we're also looking at the facts of this case. In this particular case, the judge considered the past domestic violence based on the first judgment, based on the GAL reports, both of which were there, based on, there was the police report that mother had filed with Danvers about that 2013 incident. The judge was aware of all that. So, somewhere in mother's brief, there was a suggestion that the judge refused to even consider any of these things. That's not really accurate. The judge clearly considered these things. She just was not willing to retry all of these things. And I think that's the correct result, because those things presumably were tried during the divorce trial, and even if they weren't, that judgment wasn't appealed. So
Is there a difference between the modification judge saying that she will not consider them versus the modification judge saying, these are before me and they don't rise to the level to raise a rebuttable presumption?
Oh, absolutely, absolutely. But now
And you have a better argument for door.
Excuse me?
You have a better argument if door number 2 happened, right?
Right, yeah. I mean, the judge did look at all of that. But the thing is, she doesn't even get to the point of the rebuttable presumption. I don't think she legally gets to the point of the rebuttable presumption here, because there was nothing new since the divorce to suggest that the first judge's, we don't know if the first judge refused to apply the rebuttable presumption or if she applied it and rebutted it. We don't know. And again, an appeal of that judgment may have given us that explanation, but we don't know that now.
So
All we know-
I'm just trying to understand what the general rule would be. You need new domestic violence to trigger the rebuttable presumption in a modification proceeding? Is that the rule you're talking
To
about?
trigger a new rebuttable presumption, right.
Okay, but so let me ask you, if we've got a case, no domestic violence in the divorce judgment, but now we've got this new allegation of a very serious instance of domestic violence that wasn't brought forward because the victim was frightened to bring it forward and just wanted to get the divorce over with. Could that old act of domestic violence trigger a rebuttable presumption in a modification proceeding?
Again, that's not this case, but that goes to what I was answering with Justice Cipher. I think maybe it could. You'd have to show through an offer of proof, or however the court thinks would be the best way to do it, you would show the modification judge, this evidence does exist. Yes, it's pre-existing the divorce judgment, but here's why it wasn't presented. Because I was so traumatized by this that I was afraid to raise it. Now I'm stronger. Now I can do it. And, the judge will then make a determination, presumably some sort of discretionary determination of whether or not that rises to a level that we're going to sort of go around the usual rule of, material and substantial change of circumstances, and we're going to allow consideration of this. But that's not this case. That's not what happened here.
Because, I mean, I understand your point that we don't want a situation in which, in this case, the mother basically fails to prevail earlier and then says, well, I'm going to move for modification, hope to get a new judge and retry everything. But it was you who sought modification here, trying to change it from shared legal custody to sole legal custody. Does that mean that a judge needs to look harder at the issue of prior domestic violence, because now the legal custody is being moved to a situation in which the mother is losing authority as opposed to maintaining the authority she had before?
No, I don't think so, because I don't think it's a matter of degree. It's either, so when the first judge made the determination that it is in the child's best interest for father to have custody, it's not about, well, father was only a little bit abusive, so I'm going to give him a little bit of custody. I mean, that's not really how it works. It's, would the child having any degree of custody with this father be against that child's best interest? And the judge decided, nope, it's in the child's best interest to have that custody. So now we get to the modification. I mean, why should any parent who has custody under a valid judgment have to worry, gee, if I file a modification action, even though the other parent is doing all these crazy things, if I file this action all of the past might be revisited again. You know, I mean, that doesn't really make sense, you know? Just because.
But what else is a motion to reconsider, but please reconsider the past?
But it's not a motion for reconsideration. It's a modification action.
Modification.
And that's not to reconsider the past, it's to reconsider from the point of the judgment forward.
Okay.
So, right. I mean, if we were talking to Rule 59 or Rule 60 motion, I mean, that's a different, we're not there. That's a different story.
But the mother is saying that sole legal custody means that there is less opportunity to address issues of physical violence if they reemerge, and that has important consequence in terms of the risk of a recurrence of the physical violence by the father.
And that would have been a fair argument for her to make to the modification judge, but that doesn't mean retrying the older incidents. You know, that might have been a great argument for not changing, for denying father's modification action.
So what does the judge here do, since the judge has only a bare bones finding by the judge below and nothing as to what earlier happened? How is a judge to consider the prior physical violence, both in evaluating context and evaluating the modification on what is a very limited record?
I think, you know, for better or for worse, she has to go by what the first judge found. And so the modification judge knows there was domestic violence. Some of it was perpetrated by father. It didn't rise to the level that father was precluded from receiving custody. And mother can testify during the modification proceedings that I'm still traumatized by what happened in the past, and the judge can consider that, and she can decide whether it's credible, and, you know, all of those things.
Can the judge consider what happened in the past?
Excuse me?
What happened in the past? How is the judge supposed to make that without considering what happened in the past? That had happened and what happened is two different things, seems to me.
Right. I mean, so maybe the judge gives a little leeway as far as what mother's perceptions were of what happened in the past. But again, the judge doesn't retry whether these things happened in the past or not.
Except as to new incidents.
Any new incidents.
Or those that were not tried the first time.
Well, again, I mean, I don't know that this is the case, aside from that, maybe that one 2013 incident that was alleged, but I mean, you know, I would think you'd need some sort of policy that says, if something wasn't raised before, here's how we would get it in. But this isn't really the case. I mean, the only thing here that the record reflects maybe wasn't addressed at the divorce trial is this 2013 allegation, and the judge considered it. The GAL talked about it. It's in the record. There's the police reports in the record. I mean, that's here in this case.
But it is here in the sense that the judge changes the legal custody based on the overreaction, right? That the wife hasn't gotten over the old fighting. It seems hard to separate out that from the past incidences to decide whether she's overreacting, isn't it? I mean, it's very difficult to make a determination without knowing what used to occur, what happened before. That's what worries me.
I hear what you're saying, but I don't think that means that this modification judge did not have enough information to go on. I mean, there was a lot of information, things that, you know, don't even relate necessarily to domestic violence. I mean, you know, she was making false allegations.
What is the GAL? The GAL for the modification, what does that person do in this case? I can't remember.
What do they do?
I thought there's a subsequent investigation by the GAL, right? So she talks to both parties? I can't remember what else.
Yeah, it was a male GAL who I believe spoke to both parties and the child.
And discussed the past domestic violence?
Yep, and reviewed the prior GAL's report.
And you think that's sufficient then?
It's probably on a case-by-case basis, but yeah, I think in this case it is. I mean, there was a lot going on here, you know. I mean, I know mother's argument is I couldn't help myself because I'm so scarred by the past, but some of what she was doing here was too far. Even if you assume that the worst case scenario with the past allegations. And again, I don't think the past allegations, even though we don't know the details of them, they weren't worst case scenario because the first judge wouldn't have granted custody to father if they were that bad.
Okay, thank you.
So